Good afternoon, everyone, and welcome to today's webinar provided by PAMS, which is entitled How to Handle the Non-Compliant Patient. Before I introduce our speaker for today, I would like to thank our Platinum sponsors for their continued support. Without these sponsors, we would not be able to do educational sessions like the one we're doing here today. Our Platinum sponsors include MedBill, Philips Respironics, Pride Mobility, the Med Group, and VGM. As a reminder, this webinar is approved for 1 CEU credit for RTs from the AARC and is also approved for 1 CEU for nursing credits from Grandview Hospital. We'd also like to thank Grandview Hospital and Donna Manning for their assistance in helping us to obtain the nursing credits. If you do need the CEUs, please ensure that you are completing the forms provided to you by Kelly and returning them to her by the date requested. If you have questions during today's program, please type them in the chat area at the bottom left corner of your computer screen, and Jeff will be happy to answer those questions at the end of his presentation. Also remember that this program is being recorded and you can review it again throughout the year if you like. It's now my pleasure to introduce Jeff Baird, who is the chairman of the healthcare group for Brown Fortunato, which is based in Amarillo, Texas. The firm's healthcare group has a large national healthcare practice with clients throughout the U.S. The healthcare group represents DME companies as well as many other healthcare entities. They work closely with the Department of Justice, the OIG, CMS, the National Supplier Clearinghouse, the DME regional carriers, FDA, and other federal and state regulatory agencies. Jeff has also authored numerous articles and is a frequent lecturer throughout the country. He earned a BBA from the University of Iowa and received his law degree from the University of Tulsa College of Law. Jeff is also board certified in health law by the Texas Board of Legal Specialization. So Jeff, thanks for being with us here today, and I'll turn it over to you.
Thanks a lot. Hey folks, it's my pleasure to spend about an hour and a half with you today, and it's always a pleasure for me to speak for and on behalf of PAMS and to work with PAMS. I've known PAMS for a long time. It's a quality organization, and the PAMS leadership, both the members as well as its executive director and those on the board, are certainly stakeholders in the DME industry. And so from my standpoint, it truly is a pleasure. Now, what we're going to do is we're going to talk for about an hour today about the non-compliant patient, and we're going to be focusing on oxygen. And then when we get close, probably I'll go for about, let's say, 45 minutes to an hour. And then after that, one of my partners, Lisa Smith, is going to join me, and then she and I together are going to tag team the Q&A. So with that in mind, let's get going. And again, this is kind of a fun topic, and we've seen some changes in the law over the last couple of years or so this will be enjoyable to do. Now, and this is actually kind of interesting. Mindy and I together spoke on this, I think Mindy, back in 2015 in an in-person conference for PAMS.
Yeah, that's right.
And this was a lot of fun. We did this together. Mindy approached this from a clinical standpoint. I approached it from a legal standpoint. And so what I've done is took what Mindy and I did several years ago, updated it, and brought it current, and so that's what we're going to talk about now. Now, a growing challenge to the DME suppliers, what to do with the non-compliant patient. I mean, it would make sense from a business standpoint that a DME supplier could reasonably conclude that in the absence of a fully compliant recertification CMS, that the absence of a fully compliant recertification CMN is a technical default, and we can go pick up the equipment. Now we would think that we could do that from a business standpoint. It's not quite that easy, and we'll get into that. Likewise, there needs to be information in the Benny's medical record to support that the item is necessary, is medically necessary. That being said, it's always a concern for a supplier to go pick up equipment, particularly oxygen. I mean, obviously a patient needs to breathe, and the last thing we want to do is go pick something up and have there be a bad outcome, and then all of a sudden we're looking at some type of lawsuit by a plaintiff's attorney. So we're going to get into that. Now, although a DME supplier, we have the right to refuse service to patients that cannot demonstrate medical necessity, there's a risk in exercising this right. And so in order to reduce the number of bennies who do not recertify in the first place, here are a few practical steps that we've seen our clients take. And let's see here. There we go. The reminder letters. Fairly simple, fairly routine, but certainly the DME supplier can send letters to both the physician and the Benny and the caregiver. Normally, sending a letter just to the patient himself or herself may not work for obvious reasons, but sending a reminder letter to the doctor and or to the adult child, the caregiver, the 50-year-old son or daughter, often can get somebody's attention. And the supplier can send a reminder letter 120, 90, 60, whatever days before the recertification is due, and the supplier can use this opportunity to educate the Benny about the fire safety and to satisfy accreditation requirements. Lapse notifications. If a Benny does not recertify, then certainly the supplier can send a letter again to the Benny, to the
Excuse me,
caregiver.
Jeff?
Yes.
It's Mindy. We've had a request if you could speak up a little bit or maybe increase your volume on your phone.
Sure. Is that better, Mindy?
Yes, for me it is. Yes.
Okay.
They're
Take
saying
what,
yes.
I have a headset on, and I'm going to speak louder, a little bit slower. And if somebody can't hear me, be sure and alert Mindy, and she can tell me. I'll take my headset off and just put my hold my ear to the receiver. So I'm going to speak louder, and hopefully that'll work. If it doesn't,
Sounds
I'll try
good.
to. Yeah. Okay.
Thank you.
You bet. Now, if we send a lapse notification letter, then it's not, even though it's not legally required, it's a good idea to list other suppliers from which the beneficiary can obtain a similar item. Again, this is a way to prevent problems with the beneficiary and or his or her caregivers. Now, I kind of like this, and I'm as an attorney, I'm paranoid by nature. We, as attorneys, we learn that in law school, how to be paranoid. But and normally, if somebody ever says to me, Jeff, I want to provide a gift card, I say, no, can't do it, absolutely not, no way in the world. Well, here's an exception. I have approved a DME supplier offering to give a gift card. And here in my slide, I'm just, as an example, $25 gift card to Benny, saying if you will return, you've not recertified, and so therefore the concentrator is no longer medically necessary. Therefore, we as a DME company, we're not going to get paid for it. Therefore, Mr. Smith, please return the concentrator to us. And to encourage you to do so, we will give you a $25 gift certificate. Now, this is low risk. Under the federal anti-kickback statute, this is low risk under the Benny inducement statute, because this $25 or $50 or $15, doesn't really matter, no matter what it is not meant to persuade or induce a beneficiary to come use us. It's not meant for really anything except please return your equipment. Therefore, the risk is very low that anybody would ever assert a violation of the anti-kickback statute or the Benny inducement statute. Now, despite best efforts, some Bennies will just refuse to recertify. They'll refuse to return the supply. They'll refuse to return the equipment back to the DME supplier. People do that. In this case, the supplier can ask the Benny to sign an ABN detailing lack of medical necessity to hold the patient financially responsible, or if the DME supplier is non-participating, which in my opinion it should be, then it can notify the patient that we're just no longer going to accept assignment, and so therefore we're going to provide this equipment to you on a non-assigned basis. Therefore, patient, you got to pay us out of pocket. Okay. Now, the question becomes, and this has been driving Mindy and Kelly and me and others crazy for years, and that is what happens when the doctor doesn't play nice in the sandbox. What happens if the physician refuses to provide information needed to establish medical necessity? This used to be a real problem 5 to 7 years ago. It's less of a problem now because doctors they're finally getting trained, I guess, if you will, by the DME industry that they've got to provide us what we need. But nevertheless, we're going to run into some doctors that are just not cooperative. What to do? Well, one option is to use the Dear Physician letter that we can find on the DME MAC websites. Now, does this help? It might. I mean, some doctors will pay attention to it, others will throw it away, but at least it's something. But more importantly, as you'll see here in the last sentence of the slide, the last thing that the doctor wants is to have an irritated patient. And so if we can get the Benny involved or the Benny's adult child involved and say, look, your doctor is not helping out, and we as a DME company, we cannot continue to take care of you until until the doctor gives us what we need. Then while the doctor may blow us off, while the doctor might blow off a Dear Physician letter, it's going to be more difficult for the doctor to ignore a complaining beneficiary. Well, okay, that covers slide 2. Okay, now here are a few Q&As that we think are applicable, and I'm going to give you the questions and then give the answers. Here's a question from a DME supplier. We have an initial CMN for oxygen that the doc completed. But when the recertification is due, the doctor does not complete the CNN, stating, I haven't seen the patient in a year. What do we do as a supplier? And the direction that we've received, and again, this is kind of milquetoast direction, but suppliers need to educate the Benny as well, that the Benny needs that, that we need to educate the beneficiary. You got to go see your doctor for the recertification, and if you don't, we can no longer take care of you, and we've got the right to pick up the concentrator, and we've got the right to tell you to go elsewhere, or we've got the right to switch you to non-assigned, and so therefore, 82-year-old beneficiary or 55-year-old adult daughter caregiver, you need to go in and see your doctor. Well, next question, can we refuse to service at Benny if the doctor is not compliant in getting us the required documentation? Sure, and the law says we can. We can inform the patient that the referring physician does not provide adequate documentation to determine if the equipment is reasonable and necessary. We have the right to say that. Okay, so let's go and switch gears. I want to pivot to, and I've got some more non-compliance ideas or issues that we're going to discuss later on, but let me pivot just a bit, and I want to talk about restarting the 36-month cap on oxygen patients. Now, there are only 3 situations, and here the devil is in the details, as to when we can restart the 36-month cap. The first, there are 3 ways, 3 times we can do this. The first way is after the 5-year RUL, or reasonable useful lifetime, has run. Certainly we can, and if the Benny elects to get new equipment from us, then we can obviously we can restart the cap. Restart the rental period. Or if the Benny drops the concentrator and it goes down the steps and is damaged of some type of incident of damage, hurricane, fire, flood, what have you, or if the equipment is stolen or lost, then certainly we can replace it and start the 36 months over. Or during the 36-month rental period, if the break in need is for at least 60 days plus the days remaining in the month of discontinuation. Now, these three conditions or requirements that we have to meet in order to restart the 36 months on their face seem relatively simple, and in a sense they are. The devil's in the details. And so let's kind of get down to the weeds just a little bit. Now, okay, now my computer's doing strange. Now my computer, Mindy's doing strange things. It says that it is loading. Let's see.
What slide do you want it to be on?
A second. I think I'm there. After the RUL. Let's see. That's strange. Let's see. Okay. Okay. I think I'm okay right now. If I run into problems, Mindy, I'll have you do the slides for me. Is that okay?
Yes.
All right. Now, let's talk about after the 5-year RUL has expired. At any time after the end of the 60th month, the Benny, if the Benny wants to obtain a new concentrator from us, he or she can do so. Then we can just start all over again. That's pretty simple. Now, the 5-year period begins on the initial date of service and runs for 60 months from that date. It's not based on the age of the equipment, and the 5-year RUL does not restart if there's been a change in oxygen modality or change out of equipment or anything like that, or even a change in supplier. Now, when the reasonable useful lifetime of a Benny's portable oxygen equipment differs from the stationary, then the RUL of the stationary is going to govern. It's going to trump the RUL of the portable. So here are two examples. If the reasonable useful lifetime end date of the portable oxygen equipment is before the end date of the stationary, then the RUL end date for the portable is going to be extended to coincide with the stationary. And the reverse is true. If the RUL end date of the portable is after the reasonable useful lifetime of the stationary, then the end date of the RUL for the portable is going to be shortened to coincide with stationary. Now, when the end date of the RUL of the stationary occurs, then at that time the Benny can elect to obtain replacement of both the stationary and the portable. If the Benny elects to obtain the replacement of the stationary and portable, then both types of the equipment must be replaced at the same time, and a new 36-month rental term and a new RUL is then started for both the replacement stationary and the replacement portable. Now let's talk about competitive bidding, and here I could go off on a huge tangent, but fortunately, competitive bidding is going to come to an end temporarily on December 31st. And then from January 1, 2019 until, I believe, January 1, 2021, competitive bidding is not going to exist. It's going to be the wild, wild west again, any willing provider. And so during this 2-year gap period, we're not going to have to worry about competitive bidding, but then we have to decide whether or not we're going to jump back into, we're going to decide whether or not we want to submit a bid for the next round, which will be January 1st, 2021. But nevertheless, let's just talk about competitive bidding for just one slide here. A Benny who resides in the CBA may obtain replacement of both the stationary and portable only from a contract supplier having a competitive bid contract for the CBA in which the Benny permanently resides. I think that's correct, but I think I should have added another bullet here that says that, if a Benny wants to obtain the portable and stationary from a non-contract winner in, say, the Dallas CBA, he or she can do so. But the Benny's going to have to sign an ABN acknowledging that the beneficiary is not going to be reimbursed. Now, let's say the Benny elects not to receive new equipment at the end of the 5-year RUL, And if the supplier then, and let's assuming that at the end of the 60 month, the DME supplier continues to retain title to the equipment, then all elements of the payment policy for the last 2 years, months 37 through 60, are in effect. There is no separate payment for accessories or repairs. If the Benny was using gas or liquid, gaseous or liquid oxygen equipment during the 36-month rental period, then the payments can continue to be made for those contents. If the Benny elects not to receive new equipment after the end of the 60 months, and if the supplier says, okay, well, I don't want to mess with you anymore, and so the supplier then transfers title of the equipment to the Benny, then the accessories, maintenance, repairs are statutorily non-covered by Medicare. The contents are separately payable for Benny-owned gaseous or liquid systems. And so, I mean, I guess from that point on, gosh, I guess it would be proper to ABN the patient for the accessories, maintenance, and repairs because we're statutorily non-covered, because title's now in the name of the beneficiary. Okay. A specific incident of damage. Drop it down the steps, Hurricane Michael, whatever. When that happens, then the Benny is entitled to a new piece of equipment, and the supplier is entitled to restart the 36 months. Now, this doesn't apply if the equipment has to be replaced just because it's worn out or it's just, kind of beat up. It's out of repair. Then the replacement does not start the 36 months. Let's see here. Now, the new 36-month rental period and a new 36-month rental period and a new RUL is started on the date that the replacement equipment is furnished to the Benny. Claims for the replacement of oxygen equipment for the first month of use only are billed using the HCPCS code for the new equipment and the RA modifier. Now, the supplier must include on the claim for the first month of use a narrative explanation of the reason why the equipment was replaced and supporting documentation. For example, if it was stolen, I can't imagine somebody stealing oxygen, but I guess I've seen stranger things. If the equipment was stolen, then let's submit a copy of the police report. For lost or just irreparably damaged equipment, at least let's maintain a narrative. It'd be nice if the narrative was actually prepared close to the time that the damage occurred, as opposed to a long time thereafter. After the expiration of the 36-month cap rental period, the supplier must continue providing oxygen contents to the Benny during any period of medical need for the remainder of the 60 months. Now, again, replacement of equipment in the event of damage or disaster or theft or something. In the initial CMN for replacement equipment, the initial date should be the date of delivery of the replacement equipment. Claims for the initial rental month and only the initial rental month must have the RA modifier added to the HCPCS code for the equipment where there is replacement due to the reasonable useful lifetime or the replacement due to damage or theft or loss. Claims for the initial rental month must include a narrative explanation of the reason as to why the equipment was replaced, but it needs to be supporting documentation. Now, the research CMN for replacement equipment. Repeat testing is not required. We need, as a supplier, to enter the most recent qualifying value and test date. This test does not have to be within 30 days prior to the initial date. It could be the test result reported on the most recent prior CMN. There's no requirement for a physician visit. that is specifically related to the completion of the CMN for the replacement equipment. Okay, now let's switch gears. Let's talk about during, this is kind of the third leg, or the third reason why we can restart the 36 months, and that is during the 36-month cap period after a 60-day break in medical need. Now, let's assume that if the Benny enters the hospital or the SNF or joins Medicare HMO and continues to need or use the oxygen when the Benny gets home, or the Benny rejoins Medicare fee-for-service, then the payment resumes where it left off. Now, if the need or use of oxygen ends for less than the 60-day plus remainder of the month of discontinuation, then again the payment just resumes where it left off. There's no restart. You just continue from during the next month. Now, during the 36-month rental period, if the need for the oxygen ends for more than 60 days plus remainder of the month of discontinuation, and new medical necessity is established, then a new 36-month rental period would begin. Let's take a look at the new initial CMN. The blood gas study must be the most recent study obtained within 30 days prior to the initial date. And the Benny must be seen and evaluated by the treating doc within 30 days prior to the date of the certification. Now, let's say that there is an interruption in medical necessity of more than 60 days, plus the days remaining in the last paid rental month. Then once the need for using the oxygen resumes, the supplier needs to collect supporting documentation of the new medical need, including but not limited to. And if you look at these 5 bullets, these will tell you what the supplier needs. The claim for the first month of the new rental, the claim for the first month for the new rentals has to have, meeting the above documentation, they need to include the new initial CMN and the narrative statement, break in medical need greater than 60 days, close quote. Now let's talk about during, when you have this break in need, let's talk about months 37 through 60. If the need for oxygen ends for more than 60 days, plus remainder of the rental month of discontinuation, and new medical necessity is established, then a new rental period does not begin. The supplier who provided the oxygen equipment during the 36th month must provide all necessary items and services for the duration of the reasonable useful lifetime. So now we're talking about the last 24 months. Okay, now here's, I'm going to pivot over to the ACA, the Affordable Care Act, otherwise known as Obamacare. Now, and we have in section, I'm not going to bore you with all the details, but section 6407 of the Affordable Care Act has certain requirements, and these are applicable to the following items, and you'll see 1, 2, 3, 4, 5, 6, 7, 9 items there that this applies to. Now, these items, these 9 items, require an in-person or face-to-face interaction between the Benny and his or her treating doc prior to prescribing the items, specifically to document that the beneficiary was evaluated and or treated for a condition that supports the need for the DME. A dispensing order is not sufficient to provide these items. A written order prior to delivery is required. A new face-to-face requirement is a new face-to-face examination is required each time a new script for one of the specified items is ordered. A new prescription is required by Medicare, and then here I'm list 1, 2, 3, 4, 5, 6, 6 conditions in which a new prescription is required by Medicare. For example, for all claims for purchases or initial rentals, where there is a change in the prescription. If an LCD requires periodic prescription renewal, when an item is replaced, when there is a change in the supplier, when required by state law. And the face-to-face examination must be within 6 months prior to the date of the written order prior to delivery. Okay, abandonment. This is kind of a tongue twister. In late August 2013, CMS published the following announcement regarding abandonment of patients. Let's see here. Let me just quote this, and then I'm going to kind of put it in more C-spot run terms. Effective immediately, CMS will allow for the replacement of oxygen equipment in cases where a DME supplier exits the Medicare oxygen business and is no longer able to continue furnishing oxygen and oxygen equipment. In these instances, the oxygen equipment will be considered lost, and a new 36-month rental period and RUL will begin for the new supplier furnishing replacement oxygen equipment on the date that the replacement equipment is furnished to the Benny. In other words, it kind of says what it says, but it's kind of tricky. That when the supplier, quote, exits the Medicare oxygen business and is no longer able to continue furnishing oxygen, then we can start the 36 months. I'll come back to that in a second. CMS went on to say that suppliers exiting the Medicare oxygen business with patients that were unable to transfer to new suppliers should be aware that they are in violation of the statutory and regulatory requirements for furnishing oxygen. As such, the supplier that does not continue to take care of the patient like the supplier is supposed to is in violation of the supplier standards. Now, what does all this mean? And this is something that it's if you go back to, let's see here, this slide. At one time, I was tempted to make the argument that, well, let's say that ABC Inc. Puts out oxygen, puts out bent metal, puts out soft goods, and also sells mineral. So, kind of and also sells and rents wheelchairs. Pretty much a full line DME. But the DME supplier decides, I'm losing my shirt on oxygen, so I'm going to shut down my oxygen business. I'm just going to get out of it. I'm not going to even try to sell it. No, let me digress and kind of go down a rabbit trail for a second. It's perfectly okay if you have ABC Inc. with one tax ID number, and it has several lines of business. It's oxygen line, it's sleep line, it's also a bed line of business, it's wheelchair line, and it's soft goods line of business. Pursuant to an asset sale, it can certainly get rid of one of its lines of business. It can sell to ABC Inc. its oxygen line or its wheelchair line of business, and basically in doing so, it's going to transfer its whatever hard assets it has, retaining whatever hard assets or inventory it has in that line of business, and then transfer patient files. The supplier can do that. And so I was thinking, well, okay, we now have ABC medical equipment that just is losing its shirt with oxygen and wants to get out of oxygen. And so it's not, but however, ABC doesn't want to or can't, either does not want to or can't sell its oxygen business. And so it decides it just wants to shut this thing down and just tell its patients, dear, patients, sorry, we're out of here. You're going to have to go elsewhere, and we're not going to take on any new oxygen patients. Well, at one time, I thought, well, we could do that because the way this reads, ABC is exiting the Medicare oxygen business. this does not say that ABC is exiting the Medicare business. It doesn't say that ABC is exiting the DME business. This says that the supplier is exiting the Medicare oxygen business. And so I thought, okay, well, we can just shut down and tell our oxygen patients to go take a hike, and we're going to be just fine. But then if you continue reading this, and is no longer able to continue furnishing oxygen. Well, ABC is able to do so if it desired to do so, but it just doesn't want to. Well, after looking at this and after talking to CMS and others, there's and other stakeholders out there, it's clear that in Medicare's mind, ABC does not have the option of just shutting down oxygen, telling its patients to take a hike, and then continuing on with its wheelchairs and soft goods and everything else. The only if ABC really just wants to get out of oxygen and just walk away from it, then to avoid violating supplier standards, ABC has got to just totally shut down, shut its doors, close all of its locations, all of it. And let's say ABC's got 5 PTANs all under one tax ID number. It's got to close all 5 PTANs and just go out of business. That's what this thing is saying. Now, certainly, what we've done with, again, I'm kind of dwelling on this because we've had to do this with clients, where we'll have a client, let's just say it has a location in Colorado Springs, and the client has a location in Salt Lake City and in Portland, Oregon. Okay, let's say 3 locations. And the client, the DME company, is losing its shirt in Colorado Springs. I am okay with the DME company saying to its Colorado Springs patients, hey, we're having to shut our doors here. We just ain't making it. Sorry. You really ought to go elsewhere if you can, and here's a list of other DME suppliers in the area. But if you can't land someplace else, that's fine. We'll continue to take care of you, but we're going to be servicing you long distance from either Salt Lake or from Portland. It's not going to be as convenient, but we will give you the minimum necessary service. By doing it that way, we're not abandoning the patients. We're not violating the supplier standards. So I've kind of beat that horse to death, but I just wanted you to be aware of how abandonment works. Okay, but I'll come back to this here in a second. Now, and the reason you've got to be careful with it is, again, going back to the ABC example, if ABC abandons patients but wants to keep its doors open, wants to abandon oxygen patients but wants to keep its doors open for other types of patients, ABC is at risk of having its NSC, of having its PTAN revoked because of noncompliance with the supplier standards. Obviously, ABC can sell its oxygen patients or sell its oxygen business and transfer its oxygen patients. But when ABC does that, if ABC sells its oxygen business to XYZ, and XYZ says, here, thank you very much, here's a check. In that situation, XYZ cannot restart for 36 months. XYZ takes the oxygen patients as they are. There's no restart because there's been no abandonment. You know, ABC has not abandoned any patients. It just has provided a soft landing. Okay. Now, all of this has been particularly relevant in the competitive bidding area. And again, the competitive bidding is coming to an end temporarily here in just a couple of months. But we had a number of situations where you have a ABC in Dallas didn't get a contract and has some oxygen patients that with low reimbursement, and ABC does not want to grandfather them, and ABC just want to walk away. Well, that makes sense from a business standpoint to do that, but CMS did not want that to happen. For that reason, this abandonment requirement was put into effect. All right. Now, CMS used this announcement to protect Medicare beneficiaries from being orphaned, but at the same time, well, let me back up. CMS used this announcement to protect oxygen beneficiaries who are orphaned. In other words, they are cast out to the wind. Let's just say ABC shut its doors totally and walked away. Well, from CMS's standpoint, it knows that these patients need to breathe, and so CMS wanted to motivate or encourage other DME suppliers to take these patients on, and so to the carrot, the stick, but the carrot is, the hook is XYZ out there. If you want to pick up these orphan patients, you can do so, and guess what? You get to start 36 months over. And that was the motivation behind it. So let me see what my next slide is, and I'll have to come back here. And so this announcement deterred, it was meant to deter DME suppliers that provide DME products in addition to oxygen from just stepping away from oxygen. And the deterrence, of course, is potential violation of the supplier standards. So, again, what does all this mean? Bottom line, let's just kind of look at ABC, medical equipment, does oxygen, it does enroll, it does wheelchairs, it does other types of bent metal. ABC, absolutely, if it wants to, can shut its doors. And can just say we're out of business, and John Smith, the owner of ABC, can go to work for 7-Eleven selling big gulps. That's okay. That's perfectly acceptable. Another thing that ABC can do is that it can sell 100% of its assets, everything, just wall-to-wall, enroll, bent metal, wheelchair, oxygen to XYZ. And by doing this, then ABC transfers the patient files. XYZ takes on the patient, so these patients are not orphaned. Life is good. There's no problems with that. That's number two. Number three, ABC, owned by John Smith, can carve out or sell its oxygen line of business through an asset sale and keep going its other lines of business. In other words, it keeps its doors open, keeps its P10, but it's now out of the oxygen business. XYZ has taken those patients on. Therefore, the oxygen patients are not orphaned. Therefore, CMS is happy. That's number three. Number four, what cannot happen is for ABC to tell its oxygen patients take a hike and have ABC think that it can stay open running it with its other business lines. Now, here's where you've got to be a bit careful because I've seen some suppliers try to play games, trying to game the system, and here's what I mean. We know that if ABC closes its doors and closes its doors, walks away, abandons its oxygen patients, then these patients are just kind of floating out there, then XYZ can pick these patients up and restart the 36 months. We know that. We also know that if ABC sells its oxygen business to XYZ, that XYZ cannot restart the 36 months. Okay, but what about kind of a hybrid? Let's just say with a wink, wink, nod, nod. ABC says to XYZ, you know, I'm about to close my doors, and here's a list of patients. I'm not selling you anything, but you can let's contact these patients, and ABC, will suggest they go over to you, XYZ. And so therefore, let's take the position that I've abandoned these patients because I'm closing my doors, but I'm really going to provide a soft landing for you, XYZ, where you've got the, basically you're ahead of the line in terms of picking these things up. And oh, by the way, after all this gets over said and done with, XYZ, I want you to afterwards buy my oxygen inventory, and oh, by the way, XYZ, I want you to bring John Smith, the owner of ABC, on as an employee. Now, something like that, you're gaming the system. You're trying to have your cake and eat it too. ABC is trying to guide or steer these patients to XYZ. XYZ is trying to be first in line to take those patients on, but XYZ is wanting to restart 36 months, and CMS would say, no, you can't do that. Okay, now, a closed business. So ABC just closes its doors in its entirety. What CMS has said is, okay, you can do that, but why don't you? But you need to give at least 30 days written notice to your Benny of your intention to no longer provide oxygen, and this notice has to be in one of two ways: a letter from ABC to the Benny saying we're out of here and we can no longer take care of you, and specify the date upon which service will end. Or number two, working with the beneficiary, ABC, the one closing its doors, will send a letter to the new supplier saying, here is your new patient, please take care of him. And this is a way to provide soft landings for the patients. Now, for suppliers, for the XYZs of the world who receive bennies from providers who have closed their doors. Here again it says, elected to voluntarily exit the Medicare auction business. Well, from CMS's standpoint, what this means is closing our doors and closing the doors in the entirety. So, but let's say that we have XYZ is now claimed these auction patients. They've been orphaned, they've been abandoned, and now XYZ wants to restart the 36 months. Well, XYZ then needs to include the RA modifier, which is replacement of a DME item, on the claim line for the replacement equipment, and needs to document in the narrative field of the claim that the Benny acquired through the supplier voluntarily exiting the Medicare program. And so, and then when submitting, and then I give you some other suggestions and ideas here, but this is when XYZ is inheriting these abandoned patients, this is the type of information it needs to submit. In addition to providing this information on the replacement equipment claim, in the event of an audit, then XYZ should be prepared to provide documentation demonstrating that the beneficiary was transferred from a supplier that closes doors, that got out, that here again exiting the Medicare auction program from CMS's standpoint, closes doors, shut down all 5 P10s. And examples of the documentation to meet this requirement are either the copy of the note, well, this is actually what I discussed with you earlier, which is the notice or the letter that ABC, the one closing its doors, sent to the Benny, or the letter that ABC and the Benny together sent to the new supplier, or an attestation from the Benny, from 80-year-old Mr. Jones, who says, I tried contacting ABC and all I got was a recording. Okay, let's see here. Now, suppliers, the XYZs of the world, accepting transfer of bennies are reminded that all Medicare rules apply. These include obtaining a new order, the new initial CMN. We got to have the blood gas test is not required. We don't have to repeat that. All we have to do is enter the most recent qualifying value and test date. And the test does not have to be. This test does not have to be within 30 days prior to the initial date. It could be the test result reported on the most recent prior CMN. There's no requirement for a physician visit that is specifically related to the completion of the CMN for the replacement equipment. So the takeaway for the DME supplier getting out of the auction market, this is just a repeat of what I told you before. It can sell, it can provide the soft landing, it can do that. That's great. The purchaser, the one that's inheriting these patients, is not going to be able to restart the 36 months. Okay. Now, let's talk about bankruptcy. Then I want to go back to non-compliance here in just a second. And then Lisa and I'll take some questions. Back in a prior life, a zillion years ago, I did some bankruptcy work, and so I kind of know how bankruptcy, how that does work. If a DMA supplier, let's say ABC, goes into bankruptcy. In fact, I'm just going to skip. I'm just going to talk for a second and ignore these next two slides, and I want to skip on through to another compliance issue. There are essentially 4 or 5 chapters in the Federal Bankruptcy Code. Chapter 11, Chapter 7. Chapter 11 is a corporate reorganization. A Chapter 7 is a liquidation that either corporations or individuals can use. Chapter 13 is a husband and wife that need to do a debt reorganization, consolidation. They're paying too much in credit cards and they want to reduce the amount. Chapter 12 is a farm bankruptcy, and I think you've got maybe Chapter 6 or Chapter 9 is for municipalities. So different chapters in the Bankruptcy Code. Okay. The 2 chapters we want to talk about here are Chapter 11, Chapter 7. When a DMA supplier goes into bankruptcy, it's going to either be a 7, meaning we're going to liquidate everything, and then the bankruptcy trustee is going to sell everything. Bankruptcy trustee is going to take possession of all that we have, liquidate it, pay the creditors on a pro rata basis, and then close the file. That's a 7. A Chapter 11 is when ABC says, hey, I want to keep my doors open, but we've got to reduce some of this debt, and I need to pay it out over time. Okay. Now, Chapter 11, however, can be converted to a liquidation. It's called a liquidating plan. All that means is that in a Chapter 11, the debtor, ABC, says to the court, hey, just give me time to do my own self-liquidation. I'll pay creditors and make everybody happy. Well, what CMS has said is that if XYZ purchases ABC's auction business out of bankruptcy, if it's a Chapter 7 or a liquidating 11, then in that case, in the event of that purchase, then the XYZ can restart the 36 months on the oxygen patients. And well, it's just simple as that. And there are some procedural rules you've got to follow in terms of buying out of bankruptcy. But I guess the takeaway is if we do pick up oxygen patients from a bankrupt supplier, then as long as certain conditions are met, then we're going to be able to restart the 36 months. Now this, I want to, here we go, discuss all of that. Okay, here we go. Now this is something that Mindy and I talked about and that a couple of years ago, and that Lisa and I talked about this morning, and I want to spend a little time on this. Our patient is a smoker. Our patient is not real smart. Our patient is living dangerously with the concentrator that we provide. Our patient is doing everything wrong. And the last thing we want is for our patient to catch on fire or for our patient to not breathe and to die. And we know that what's going to happen is that we have way too many starving attorneys out there. And if the mindset of plaintiff's attorneys is that it doesn't matter who's at fault. Rather, if there's a bad outcome, we need to sue somebody. And so even though Mr. Jones, our patient, is just a complete nutcase and is doing everything wrong and is using our concentrator dangerously, nevertheless, we know that if something bad happens to him, we're going to get sued. Now, hopefully, we've got liability insurance that will cover it, but nevertheless, that's not a problem that we want to inherit. What to do? I don't think, and when Lisa joins me on the Q&A, we can talk about this. But just because a patient is using, in fact, Lisa, are you on right now? No, I can't tell if she's on mute or not. Oh, well.
Yeah, I'm here.
Okay, in fact, let's just talk about this. This is the last point I was going to talk about before we got into the Q&A. If Mr. Jones is a nightmare of a customer and he's really abusing the concentrator, he's smoking it, he's being dangerous and everything else, then there's a legal term out there. It's called CYA. And what the supplier needs to do is do everything it can to cover itself. And that is, the evidence needs to show that the supplier has warned Mr. Jones verbally and in writing, don't smoke. Don't keep your concentrator next to the furnace. Don't do crazy things with it. It would be wiser if the DME supplier would also notify the beneficiary's caregiver, the adult children, and also notify the doctor in writing. And let's get everybody involved in saying, look, we're putting the whole world on notice that Mr. Jones is a disaster waiting to happen, and we are demanding that Mr. Jones quit doing these things. That, short of going out and picking up the concentrator, there is not much else we can do. Now, I suppose that, at least it's something you and I did not talk about, but if ABC, medical equipment, is non-par, then I guess it could say to Mr. Jones, hey, we're going to switch you from assigned to non-assigned. You're going to start paying cash. And if you can't pay us cash, then we need to pick up our concentrator, and you need to go elsewhere. I guess we could try that and see if we could call his bluff. But I'm thinking, and I would sure invite the group here on the webinar to give us your thoughts as to how to handle this type of non-compliant patient. But I'm thinking that the best, probably the most practical course is to do all that we can to put the whole world on notice that we have educated the patient as well as the caregiver and doctor, and then not much else we can do. It would be very difficult to pick up the concentrator. Lisa, do you have anything to add to that?
Well, I guess depending on, again, how risky it is for the patient, you might want to visit with the patient's physician and see if you could get them to, agree to a DC order that would allow you to pick it up, discontinuation, because, again, is it really in the patient's best interest to have that oxygen equipment in the house if they're putting, themselves and everybody else at risk? And obviously, if you get a DC order from the physician, then you'd be entitled to pick it up.
Right. Okay, Mindy and Kelly, I've gone for about an hour, and I've got my partner. By the way, folks, my partner, Lisa Smith, she's one of our senior healthcare group attorneys, and we have 18 attorneys in our group, and Lisa is our resident oxygen guru. And so I asked Lisa to join me on the Q&A so that we can tag team this. And so Kelly and Mindy, we're happy to answer any questions that the folks might have.
Okay, great. This is Mindy. Thanks, Jeff. And Lisa, welcome to the webinar as well. We do have some questions. I'll just take them in the order as they're appearing in our chat box. And again, folks, if you do have questions, now's the time to type them in there. So the first question is, doesn't the patient have to have a face-to-face visit stating the patient is using the oxygen and needs to continue, let me see if I can move down here, prior to a research CMN?
Yeah, the oxygen LCD basically says that when the patient's up for research, that they have to have been seen and reevaluated by their physician within 90 days prior to the research date. And if for some reason they don't get in within that time frame, then once they do get in and are seen and reevaluated, then the rental would kind of pick up on whatever that recertification date is.
Right, correct. The next question is, in the event that a patient refuses to recertify, it is highly unlikely they would agree to sign an ABN. Are we not within our right to bill the patient, to bill the patient for the equipment without an ABN since they have chosen to be non-compliant?
If the patient's, if the supplier is non-participating, where they can select to go non-assigned,
right.
and assuming it's not a competitive bid area, then yeah, you could do that. You could just choose to move them over to non-assigned and go that way. But if it's a participating supplier or if it's a competitive bid patient, where essentially you're required to accept assignment, then really the regulations are that you can't bill a patient without them having an ABN signed. Now, there are some provisions in the Medicare manuals that talk about, what if a patient refuses to sign an ABN? What kind of additional documentation would you need in those kinds of situations? And I'd have to go back and look exactly what it says, kind of how you cover yourself in that situation. But there is some language in the manuals that address that.
All right, the next question, when talking about the ACA items and noting that a WOPD is required prior to delivery, shouldn't that be a 5-element order?
Yes.
Okay.
Yeah.
Indeed. Moving down here, bear with me. Okay, so next question. What about the smoking patient who lives in an apartment building or is putting others at risk?
Okay. Mindy, let me pose this to you, Mindy. What are your thoughts on that one? Yeah, I'm asking you, Mindy. What are your thoughts on that one?
Well, when we've talked about this in the past, a lot of companies will, try to get the patient to sign a form that kind of releases them from liability, let's say, on paper at least, that, they've been warned to not smoke and so forth. I'm not sure, honestly, in a lawsuit situation that would go very far to help that particular company. But I've always been under the impression that, if we've exhausted all the other efforts that you talked about earlier in the presentation, if you've tried to re-educate the patient, if you've warned them, if you've gotten them to sign this piece of paper, if you've gone to the physician and he or she says, no, I really can't, give an order to pick up that piece of equipment, I truly think that, from a company perspective, if you look at your rights and responsibilities that you ask the patient to sign typically as part of an initial setup, and that patient isn't able to or refuses to meet your right or patient responsibility, where it says something like, you have to provide a safe place for our equipment. If they're not able to do that, I think it's appropriate to give them notice and tell them you're not, providing a safe place for this equipment, particularly with, as the question is posed here, if it's a dwelling where there are others that could be put at risk as well. In those cases, I've seen companies successfully go to the landlord in those instances and ask the patient to either, abide by the rules that we're giving them or leave. So all these things, you have to look at the individual scenarios. But frankly, I don't know that from a company perspective, I'd want to be leaving my equipment out there in those unsafe circumstances. But from a legal perspective, I think that's more in your territory to answer. But from a business side, I just don't think it's a safe situation. And giving the patient 30 days to either get on board or try to find another provider. Again, it's not. There are no good scenarios in any of those suggestions. So
that's a good. Actually, Mindy, that's a good. Good idea in terms of talking to the landlord. I hadn't thought of that. There are probably 10 different things that the supplier can do short of picking up the piece of equipment that show that the supplier has done everything humanly possible to rectify the problem, short of getting some type of writ of attachment and asking the local sheriff to go in and take it, which the supplier's not going to do.
Actually,
So,
Jeff, that has happened where,
seriously?
you know, the patient, you know, maybe not so much in the smoking scenario, but, you know, if they're, you know, trying to hold our equipment hostage, so to speak, you know, then unfortunately we have had to get police involved. Sometimes they're not willing to do that, but, yeah, it's happened in the past, certainly.
Okay, that's going to be rare, but okay, that makes sense. I think the key there that I'm going to ask Lisa to weigh in, I think the key is first and foremost, and I know I'm preaching to the choir here, but the DME supplier needs to have a liability insurance policy that it knows will cover this type of scenario. So at least that's the ultimate safety net. That's number one. Number two, unless you are a competitive bid supplier servicing a competitive bid patient, whether it, but let's take competitive bidding out of the equation for just a second. And again, the next 2 years we're not going to have competitive bidding. A DME supplier can refuse to take on a new patient. DME supplier can just say, no, you're a smoker. You live on the 8th floor of an apartment building and you smoke. I don't want you as a patient. You need to go elsewhere. And that, you know, that may be the, you know, that's kind of a threshold step that the DME supplier can take. And then everything else after that, once the patient does have possession of our equipment, but we now know afterwards that what the patient is doing is dangerous, that's when we take all of these other steps, including really, as long as we do so legally, really trying to be aggressive in going in and taking possession of the equipment back. I mean, there are some steps that we can take short of sending the sheriff in, where hopefully we'd be persuasive in getting the equipment back. Lisa, any thoughts?
Well, again, you know, kind of as a last resort, also if the physician particularly won't give you a DC order, is, you know, the requirement to continue to providing the oxygen equipment. There's a provision that basically says that you have to do that unless you are kind of given a reprieve by the DME MAC. So when you have one of these really difficult situations, you could always appeal to the DME MAC medical director and say, look, this is just a no-win situation for us. Can you, you know, give us some relief here?
Okay. Very good. Also, just another comment on the actions that the company should be taking in these cases. Absolutely document constantly any contacts that you're having with those clients, their families, and so forth. Should something happen down the road, at least you can show the good efforts that you made to protect that patient and others. So
Maybe that's a good point, because often your oxygen patient who's using it dangerously, it's not going to care. It's going to be clueless when we try to tell him or her, hey, you got to quit doing this. The person can't breathe. The person's old. The person's sick. You know, there's just not going to be. I'm not sure we're going to get through to 82-year-old Mr. Jones. But once we bring into the picture his doctor and his 58-year-old daughter, then you know, we might be able to get somebody's attention who is thinking clearly. So I absolutely agree with whoever said that you need to bring others into the picture and have it documented. That's about as far as you can go.
Okay, the next question here, how should we handle a situation in which a beneficiary has passed away and the caregiver or landlord refuses to give the rental equipment back?
I love it. I'll start off on that one, Lisa, and then you can jump in. Well, at least we don't have to worry about putting the patient's life and putting the patient's safety in jeopardy. So That's one worry we don't have to worry about. Now we're just fighting over a piece of equipment. Frankly, I could go down some real rabbit trails here, but okay, if a probate has been filed, in other words, the deceased had a will, and the executor has filed the will for probate, then the supplier can file a claim. In fact, can go into probate court and say, title to this oxygen is mine. And so therefore, probate judge, please issue an order ordering the executor to hand me the concentrator. That's not terribly expensive to go in and do that in probate court. Okay. And I would like to think that, unless I'm missing something, the probate judge would say, sure, I mean, the title is yours, ABC, so absolutely, executor, give it back. Now, let us assume for a second, though, that there's not a probate. So if there's a probate, it makes life a lot easier. If there's not a probate, then the ABC can have its attorney write a nasty letter to whomever has possession of the equipment saying, it's our equipment, you're not giving it to us. That is what's called conversion or theft. You can't do this, and unless you turn it back into our client, unless you give possession back to our client within, 10 days, then terrible things are going to happen to you. And that might be enough to get the attention of whoever receives the letters. The last thing he or she wants to do is go and hire some attorney to fight over a used piece of equipment. That's number two. And number three, if we really want to make this our life's ambition to get the oxygen equipment back, we can always file a lawsuit, and then there are some procedural things that you can do where you ask for what's called a writ, W-R-I-T. It's either of attachment or sequestration, where you can go in and ask the court to order the executor to give possession of the equipment to the supplier pending final determination by the court. So as I see it, those are the three steps. Lisa, do you have anything?
Nah, not in addition to that.
Okay.
Very good.
By the way, Mindy, I'm really proud of myself on that one. And I mean, I just put my old, back a zillion years ago, I did some litigation, so that feels really good to start to talk about things I really haven't done in many, many years.
Well done, Jeff. Great
Thank
to help you out there, make you think
Sure.
harder than you have to normally, maybe.
Right.
Okay. Let's see here. This question is similar to what we were talking about a few minutes ago. If a patient is in an apartment building and smokes, education has been completed, but the physician will not discontinue the equipment, who is liable if the apartment burns down and injuries occur?
It is my opinion, that one's so tough.
Mm-hmm.
From a legal standpoint, if we've done all that we can do in terms of educating and advising doc, caregiver, landlord, then if the apartment building does burn down, we will get sued. Others will get sued as well. And our insurance company will hire a law firm that will defend, and the defense attorney is going to raise the defense of, it's called either comparative or contributory negligence, which is, hey, it's Mr. Jones's negligence that caused it, not ABC's. And I'd like, realistically, realistically, the case will eventually get settled. Probably the DME company's insurance company will pay some money just to get rid of it. It's unfair, but I understand that, but that's probably what will happen. But I think ultimately, under the theory of either contributory or comparative negligence, most of the liability will rest on the shoulders of the patient and or even maybe his caregiver and or the landlord. I guess there could be some liability imposed on the DME supplier, but whatever percentage of the negligence that's imposed on the DME supplier should be relatively small. I suppose that if I was a plaintiff's attorney, I would say, and of course hindsight's 20/20, I would say, well, DME supplier, you should have hired an attorney, gone in, filed a lawsuit, gotten a writ of attachment, and had the local sheriff's department go break through the front door and grab the concentrator. If you had done that ABC, the apartment building would not have burned down. Well, that's not reasonable to ask us to do that, but that's what the argument would be. And so I guess as I see it, Mindy and Lisa, and this one's tough, we either go all the way up to that line, all the way up to the point where we don't take the equipment back, but we do everything we can short of taking the equipment back, and cross our fingers and hope that's enough. Or if we're really, really that concerned, then I guess we just basically pull out all stops and go get a writ of attachment. And as Mindy suggested, we just have the sheriff go in and take it. That's kind of the nuclear option, but we can do that if we are that concerned.
Okay. And also, there are those, I'm trying to remember, I think they're called Oxy Safe Devices. There are different vendors out there who have these available that will stop, let's say that flames do happen through smoking or whatever. These devices can be put in line with the patient's cannula or tubing to hopefully stop the flames from traveling back to the device or spreading further. So there is that option available too if, as part of your education you install one of those to try to prevent some more hazardous occurrences. But again, that really doesn't prevent the possibility of patient injuries and so forth completely. Okay, switching gears on this next question is, can you bill for oxygen as assigned for one member and unassigned for another member on the same day?
Lisa, you got that.
Yeah, basically if you're a non-participating supplier, the choice on whether to accept assignment or not is essentially on a claim-by-claim basis. So just because you're accepting assignment for some beneficiaries doesn't mean you have to accept assignment on all beneficiaries. And if you find yourself in a situation where you no longer want to accept assignment for a particular beneficiary, our recommendation is that you kind of give them 30 days notice so that they can try and find another supplier if they want to that may continue to accept assignment. But yeah, you're within your rights to change that designation. But again, we recommend that you usually give them 30 days advance notice before you start billing non-assigned.
Okay. Next question, can we bill for portables if the patient is on 24 hours and doesn't reorder cylinders or tanks within 6 to 12 months?
That's one of the situations where, Medicare basically expects you to stop billing for equipment when it's no longer in use. So if you have a patient that's, pretty much bedridden, I guess the question is, do they in fact really need portable oxygen? Well, maybe they need it to go to a doctor's office, but they're not getting out very often. You would probably need to contact the beneficiary and assess what their situation is, whether they in fact still have a medical need for portable oxygen. And, if they're just not ordering tanks because they're using it very infrequently, but they still have a medical necessity for it, then it would be appropriate. But if you find out, their situation has changed and they really don't need or qualify for portable oxygen anymore, then you probably ought to, again, get a DC order or at least not continue to bill for it if you know it's not medically necessary. and or that they're not using it. Even if it's medically necessary, if they're not using it, like CPAP patients, maybe a CPAP's still medically necessary, but they're just not using it anymore, you can't continue to bill for it.
Okay. So somebody is asking, so would that be a Hipaa violation? I'm assuming perhaps incorrectly that they're talking about when we were reviewing the smoking oxygen patient, telling everyone, perhaps the landlord. Not sure that's what the question is, but that's probably
no, that's a valid question. Let's talk about that for a second. So, interesting. Certainly, we would have the right to tell the doctor, and I suppose, we'd have the right to tell the caregiver. We might need in advance when we sign the patient up to have a HIPAA authorization allowing us to communicate with the caregiver, so that would be fine. But that's really a good question I hadn't thought of, which is if we call or send a letter to the landlord that says, did you know Mr. Jones on the 8th floor has got oxygen and he's a smoker and he's going to blow up the building, is a HIPAA violation? And maybe. I'm not aware of, I'm trying to think if there's an exception in the HIPAA law that would allow us to do that, to make that disclosure to the landlord, or I'm wondering if the workaround would be, I don't know what the workaround would be. I don't want to be Clinton-esque here and start talking about the definition of is, but, do we be kind of disingenuous and say to the landlord, hey, did you know that Mr. Jones on the 8th floor is a smoker and is using a piece of equipment without naming the equipment, and he's a danger to your apartment building? Is that the disclosure of PHI by the DME supplier? Maybe, because the disclosure to the landlord will be coming from an obvious healthcare provider, which is a medical equipment company. I don't know. I'm not sure I've got the answer to that. I guess that's something, Lisa, where if we were ever presented, we'd have to see if there's some way, see how comfortable we are in talking to the landlord. Any thoughts?
Yeah, I don't know the answer to that offhand, but I think that would be something we'd just need to look at the HIPAA regulations and see, what you can or can't disclose in that situation if you believe that, they're putting other people at risk.
I think as an attorney, I would pretty much do everything I could, short of committing my practice, to find some way to get word to the landlord. And I don't know what I mean by that, but I just think it would be important. So that's something that we don't have an answer to right now. That's a good question.
Okay. And I will say that how I've seen that work in the past, and again, it's fine line to your point, but I think how I've seen it work in the past is that they've said to the patient, look, is it okay if we talk to the landlord? They say no, or they might say, I don't care what you do, and then what you do is have the landlord come with you to that room, to that apartment, and explain, there is a safety issue. And again, it's not a clear situation, but again, when there's public, safety at risk.
That's a good point. I mean, that's a good point. You're not, by asking, if you could just ask the patient, can the landlord and I come visit you together?
Yes. That's
not even a HIPAA authorization. That's just, sure, I'm okay with having somebody come visit me, and I think that's okay. I think I'm okay with that. And I guess we could even be so bold as to have ABC call the landlord and say, we're not going to tell you why, but go visit Mr. Jones on the 8th floor. I don't know. I mean, something like that. Maybe that would work. But as Lisa said, and as you're suggesting, Mindy, that's a case-by-case basis.
Right.
We would pull out all stops to find a way to legally get the landlord involved.
Okay. So next question, will many of these same recommendations apply for a home ventilator patient? At any point are we able to file as stolen equipment with the local police if the patient refuses to pay for the equipment in an unassigned case? We tried this and the police advised that it was not considered stolen and we have to file a writ of, I'm not sure what that word is, instead of...
Replevin.
Thank you.
Replevin.
Replevin, which involves attorneys. Thank you.
Interesting. Well, help me out here, Mindy and Lisa, with the vent. With the oxygen, we know that title stays with the supplier. Is that true with the vent, or does title? I should know this, but I don't. When the vent is placed with the patient, does title transfer, or does title stay with the supplier?
Title stays with the supplier. Ventilators are usually considered items requiring frequent servicing, and so they're not kept rental items necessarily.
In that case,
at least the last time I looked.
Yeah. Okay. In that case, I'm thinking that.
Is that your understanding, Mindy? Is that still?
Yes.
Okay.
In that case, I'm thinking that everything we've been talking about as far as oxygen applies equally to vents. Well, I think legally everything is exactly the same.
Okay.
In other words, if the patient refuses to give back to us a piece of equipment that we own, then the law says the patient can't do that. That's either theft or conversion or whatever you want to call it, and so we're entitled to get that back. But if the patient says, I'm not going to give it to you, take a hike, then there has to be some type of physical intervention. That's usually, as the listener suggested, a writ of replevin or sequestration or attachment or something where the deputy goes in and grabs it pursuant to a court order. But you got to be careful with vents. I mean, it's one thing. I mean, oxygen is very important to a patient. A vent's even more important, unless, of course, the patient, I don't know, maybe the patient's not using it, or the patient's using another vent or something. But if the patient is using our ventilator, then you got to think long and hard before going and taking it. But if the ventilator is just sitting there in the closet, the patient's going to sell on eBay, then sure, I think we could have the intervening sheriff's department to go in and grab it for us.
Okay. All right, next question. If you bill non-assigned, then you need an ABN, correct?
No. Let me do this one, Lisa, and then correct me if I'm wrong.
Okay.
Just when you billing non-assigned, all that means is, patient, you pay us, Medicare is going to reimburse you, and we're just assuming that the product is covered by Medicare. The only time that you use the ABN is when we know, or reasonably should know, that Medicare is not going to cover it. And so when ABC sells or rents a product on a non-assigned basis to Mr. Jones, and we've got the documentation in place that says that Mr. Jones qualifies for it, then an ABN is not appropriate. You don't have to worry about it. Only when we are handing the product to Mr. Jones and he's giving us his visa, but we know that, look, that we just don't have the documentation to support Medicare reimbursing Mr. Jones, then only then we say to Mr. Jones, sign the ABN.
I agree.
Okay.
Yes. Okay. Looks like the last question and comment here so far. Shouldn't there be posted signs on any public doors, etc., no smoking, oxygen present? We hand these out with every oxygen setup and ask them to post on the front and back door or window.
Smart.
Yes.
I'm not smart. I'm not aware of a law that says you have to do that, but whoever is suggesting that is very wise. That's very, very smart.
Right. And a lot of the accrediting bodies will be looking for that too. And again, it's a good thing to do to warn the public and anybody coming in, hey, no open flames, no cigarettes, that type of thing. I will say that some patients, we would post the signs. We'd go out the next time to do a delivery of cylinders or whatever, and the signs will be down. And they just don't like having people know that they have oxygen in use. Sometimes it's a privacy thing, but other times it's just they want to smoke in there, and this is the exact type of patient scenario we've been talking about for this presentation. So it looks like so far that's the last question and comment that we have. So we'll wait another minute here and see if we have anything else come in. And while we're waiting, I just want to talk about another webinar that's coming up here on October 31st, also at 2 p.m. Eastern. It's going to be presented by Jane Bunch from Jane's Healthcare Consulting, and it's entitled "The Eagle Has Landed, Now How Do I Bring It Home?" And in this webinar, Jane will be talking about how to efficiently design your organization so that you can fly through the intake and billing process with auditing capabilities along the way to make sure you're in compliance at any time you transmit, all the way to collecting the secondary and posting the payments. It's important to note for this one that if your company attended the PAMS Fall Program back on September 12th, Jane is presenting this webinar for free. So go out to our PAMS website, which is pamsonline.org, to sign up. If you did not attend the PAMS Fall Program, you missed a good program, but you're welcome to sign up as well for our usual member and non-member prices. Also, we have another webinar on November 20th, also at 2 o'clock. Jane will be doing that one, and it's entitled HIPAA is Not a Silent Monster, Kill the Anxiety of Being HIPAA Compliant. So again, timely topics, just like the one that we heard today from both Jeff and Lisa. Also, finally, save the date. Our PAMS Spring Billing Seminar will be held on February 20th, 2019. Hard to believe. We're almost to 2019, and that will occur in York, Pennsylvania at the Wyndham Garden Hotel. So let me see if we have any more questions or comments. I don't think so. Jeff and Lisa, thank you so much. As always, very informative. This was a great conversation and question and answer session as well. So appreciate all your time and everything that you do for PAMS.
You bet. Thank you so much, Mindy. And again, Brown Fortunato, we are we very much appreciate the relationship we have with PAMS. And, you know, Mindy, anything you need from us, we'll give you. So we really appreciate working with you.
We appreciate you guys as well. Thank you so much for all of your support, and hope everybody has a great rest of your afternoon. Thank you.
Thanks, folks. Bye-bye.
Bye. Bye-bye.